Hello, you're very welcome to SIPTU College's Advanced Shop Steward Training in Employment Law module. The course will be ran over 8 weeks, and this week, week 1, we're going to be looking at source of law. My name is Niall Phillips. Some of you may or may not know me, but I've been working for SIPTU for the past almost 17 years, working as a collective official and in SIPTU's Workers' Rights Centre for a number of years, and have in the last 2 years moved into the college. Now we're going to be looking at, over the course of this slideshow, we're going to look at what is law very briefly. We're going to look at source of Irish law, which are common law, statute law, secondary legislation, the Constitution, European law, international charters and conventions. We're going to look at law and fact. We're going to look at standard of proof. And we will have a look at labour law, which is made up of employment law, trade union law, and industrial relations law. Now, something just for you to consider, I suppose, before we meet on the first night. But just think about how the law impacts on your daily life. Now, for most of you who are shop stewards, you will have an understanding of employment law and how it impacts, or maybe not, how it impacts on your daily working life. But just in life in general, just consider how the law impacts on your daily life. And just consider, did the law help or hinder your day? I mean, your journey here today, but just overall in your day, did the law help or hinder you? Just to think about law, how it impacts on your life, how it helps your life, or how it may negatively impact on your life. And again, just to consider, what have the various laws you identified all got in common? So just things to consider before we meet in the first class. Okay, we're looking at a definition here from the Open University, which states that law is a set of rules created by state institutions which make laws through the authority of the state. The laws have sanctions which are recognised by the state and enforced by state authorised bodies. And another definition here sees law as a technique for the regulation of social power. So what do these definitions tell us about the law and who is responsible for making the law? Sources of Irish law. Irish law, many of you may not know, but it derives from 6 sources. The first source is common law, and we'll have a look at that in a bit more detail in the coming slides. The second, and some of you may be more familiar with it, is statute law, which is law made by the Oireachtas. And there's delegated or secondary legislation. There's the Irish Constitution. There is European law, and there are international conventions. Now, the international conventions, while important, don't have a huge impact on Irish law as such. But we'll have a look at all of these sources in a little bit more detail. So, common law. Common law is judge-made law in decisions handed down on the basis of evidence presented in court proceedings. It operates on the principle of precedent. And you may have heard of it in the workplace. You might have heard of precedence, but precedence is a legal case that establishes a rule or a principle. The rule or principle is then used by the court or other judicial bodies when deciding later cases with similar issues or facts. And common law has thus developed through the accumulation of various court decisions in civil cases over many years. Now, as trade union officials, some of you may be familiar with the term precedence, but we would use precedence sometimes in work-related issues or in trying to sort out work-related issues. For example, in a redundancy situation. So you could have a workplace where there has been a previous redundancy deal done maybe 6-7 years previous. And we say, for example, the previous redundancy deal was 4 weeks pay for every year of service. And today we're faced with a similar redundancy situation, but the employer is only offering 3 weeks. Now, we would argue, based on the previous deal, the precedents set 6 or 7 years previously, that 4 weeks were awarded previously, so that precedent should stand, and therefore the people going out on redundancy should also receive that 4 weeks. So that is precedence, is using something in the past to try and decide in the present. So common law continued. Many common law rights and duties are significant for employment law. They impact on each employee's contract of employment, and in the coming weeks we will look at contracts of employment, so we'll elaborate more on that as we go along. Now, employees, for example, have a common law duty to their employers to make themselves available for work, give faithful and honest service, obey reasonable and lawful orders, and exercise care to themselves and fellow employees. So they're common law duties we have. They may not be enshrined in legislation, but the courts have decided in previous cases that these common law duties apply to employers and to employees. So equally, employers owe certain common law duties to their employees, including to pay the agreed wages, in certain circumstances to provide work, and again exercise care in the organisation and operation of the workplace. So another example of employers owing a duty of care to their employees in common law would be to provide you with a safe place of work. So health, safety and welfare in the workplace. Even if the legislation, the Health, Safety and Welfare Work Act didn't exist, your employer still has a common law duty to provide you with a safe place of work. And these rights and duties are implicit in every contract of employment. Again, we will look at contracts in a little bit more detail as we go along. But for example, your contract, if you have a written contract, what's written in that contract are known as express terms. They're there in writing, they're for everyone to see and everyone knows about them. But also implied into your contract, while it might not be written into your contract, implied into your contract is a common law duty owed by the employer to you. So statute law is a second source. So statute law is what's known as primary law, and it's laid down by acts of the legislator. For example, the Unfair Dismissals Act 1977 or the Industrial Relations Act 1990. And we'll have a look later on in the module at these various pieces of legislation. In Ireland, the legislator is the Oireachtas. The Oireachtas is made up of Dáil Éireann, Seanad Éireann and Uachtaráin Éireann, or the President. An act begins life as a bill and goes through 5 stages in the Dáil and Seanad. When a bill has passed all stages, it is sent to the President. When the bill is signed by the President, it becomes an act. And the law must not be repugnant to the Constitution. Now, again, just to consider before we meet what this line actually means. So what are we talking about when we say that the law must not be repugnant to the Constitution? Just again, something for you to consider and maybe have a look at before we meet. Now, we've looked at common law, we've looked at primary law, now we're going to look at delegated or secondary legislation. This is a little bit more complicated, but if you bear with me, we'll hopefully make sense of it for you. So orders or regulations made by the Minister which were provided for but not fully specified in the original Act. These orders are always given a statutory instrument number. So when you see SI before a piece of legislation, you know automatically, or should do, that it's statutory instrument, that it's secondary or delegated legislation. Now, for example, some of you may be familiar with SI 146 of 2000. Now, what that basically means is SI is a statutory instrument, and it was the 146th statutory instrument of the year 2000. That's all that means. So this SI 146 of 2000, under the Industrial Relations Act 1990, it's a code of practice on grievance and disciplinary procedures. Now, most of you working will have a written disciplinary and grievance procedure. SI 146 of 2000 is a code of practice. It's what all disciplinary procedures should at least adhere to and not provide any less than. Now, again, there's a lot of information here in this slide, and I'll just sort of give it to you in brief. When the 1990 Industrial Relations Act, which was the primary piece of legislation, was enacted in 1990, it allowed, the original piece of legislation allowed the minister at some time in the future to implement a code of practice on grievance and disciplinary procedure. So the primary legislation was the 1990 Act. But that section within the 1990 Act, which provided the minister at some time in the future the ability to produce a draft code of practice, when that code of practice was drawn up. So if you notice, the original act is 1990. The code of practice was produced in 2000. So it was 10 years after the principal piece of act. So in the original act 1990, there was a section which allowed the minister to produce a code of practice on grievance and disciplinary procedure. So the code of practice then that came out of primary legislation is now known as secondary or delegated legislation. Again, I won't go through this slide, but you can read it again at your own convenience. So we're looking at the next source of Irish law, which is the Constitution. And the Constitution sets out the basic law of the state. No other laws can be in conflict with the Constitution. It can only be amended by a referendum of the people. For example, the 34th Amendment of the Constitution, the Marriage Equality Act 2015, provided that persons may marry without distinction as to their sex. But that referendum was put to the people of Ireland, who had a say or a vote on whether this was passed into the Constitution or not. The Constitution lays down the fundamental rights of citizens. For example, Article 40, Section 613 guarantees the right of citizens to form associations and unions. However, there is no constitutional obligation on employers to negotiate with trade unions as part of the employer's right to disassociate. So while Article 46(1)(3) guarantees the right of the citizen to form associations and unions, subsequent judges then decided that as the citizen has the right to associate, the employer also has a right not to, or to dissociate, not to recognise trade unions. So it's a bit of a contradiction, but that was judges reading into the Constitution, I suppose, other ways of looking at it. So while we have a right to form and associate, the employer also has a right not to negotiate with trade unions. Now we've got European law, and a lot of employment law that we will look at over the coming 7 weeks will have derived from Europe. So European law is important for employment law in this country. So the Third Amendment of the Constitution of 1972 allowed Ireland to become a member of the European communities, with 83% of voters supporting membership. Ireland joined the EEC, as it was then known, on the 1st of January 1973. The Irish state accepts certain obligations as part of EU membership, and these come through EU regulations, directives and decisions. Regulations are binding on member states, so a regulation that's passed in Europe automatically becomes law in member states. A directive binds member states to conform by introducing legislation. So again, we will look at later on in the course the Organisation of Work and Time Act, and some of you may have heard of the 48-hour working directive, which means that over a period of time, the most hours we can work in any week over a period of time, of course, is 48 hours. That came as a directive. It's known as the 48-hour working directive. So that directive was passed by Europe, but then the member states are given a number of years, normally 1 to 2 years, in order to transpose that directive into legislation. And then we have decisions which relate to specific enterprises or specific member states and are binding exactly as issued. And again, don't worry about any of this. We'll discuss it more as we go along, and hopefully when we meet we'll have further discussion on it. And any issues or questions you have come out of these slides, please keep them in mind and raise them during the class, and we can discuss them further and elaborate on them. And then we've got European and international charters and conventions. So EU Charter of Fundamental Rights is binding on Ireland, but only where a question of EU law arises. The European Convention on Human Rights is indirectly incorporated in Irish law by the ECHR Act of 2003. There's a European Social Charter, which Ireland ratified this charter in 1964, and the revised charter in 2000. And it accepts 92 of the 98 revised charter and is reflected in much of the labour law that follows in this course. And conventions of the International Labour Organization, the ILO, there are 189 conventions, of which Ireland has ratified 73. Okay, so that was the sources of law. Just they're handy just to know. Common law we'll talk a little bit more of as the course goes along. And most of the legislation we will look at is primary legislation. Again, we'll touch on the delegated legislation, and throughout the course we'll also mention EU law, of course, and the Constitution. Now, law and fact are important. Legal cases consist of considerations of questions of both fact and law. Now, questions of fact can be resolved by consideration of evidence, while a question of law involves asking what is the legal significance of a fact or consideration of procedural matters. Again, don't worry too much about this. When we look at the Unfair Dismissals Act, we'll explain this a little bit more. But some of you who have been involved in workplace investigations will know that in any investigation, you're going to look at the facts of the case. Who says what to whom, when they said it, where they said it, what witnesses were available, etc., etc. So they're the facts, and in any case, even when you go to the WRC or the Labour Court will look at the facts of the case. What the Labour Court then will decide, we'll say, for example, if it's an unfair dismissal, is what the law says, what the law expects. So it's applying the law to the facts of the case. That's all this is about. Now, just again, for your own sake, just to differentiate between civil law and criminal law. In civil law, it's a private individual or an organisation who sues for a declaration, damages or an injunction. So civil law is individuals suing each other, taking case against each other. Whereas in criminal law, it's the state, the DPP, who prosecutes on behalf of the people to secure a conviction leading to probation, a fine or imprisonment. So just in your own minds, differentiate between civil law and criminal law and what's expected. Now this is important for us because it's workplace investigations and work-related issues that we will be looking at over the next number of weeks. So the standard of proof is important, and just to have this clear in your own heads as well. In civil law, the standard of proof is based on the balance of probabilities. And that differentiates from criminal law, and any of you who've watched TV programs, read newspaper articles on criminal law, a charge must be proven beyond reasonable doubt. Now, the difference being in all of this, that any workplace investigation we're involved in, the standard of proof will be the balance of probability. And the balance of probability is very simple. And I use the example of maybe a bullying harassment case, where there may not be any witnesses to the event, the alleged event. So it's person A is accusing person B of saying or doing something. Now, with no witnesses, an investigator still has to decide, or may decide, based on the balance of probability, what is the likelihood that person B said what is being alleged to person A. And that is the balance of probability. Having looked at all the evidence, having listened to the various witnesses, if there are, or having listened to the accused and the person making the allegation, what is the likelihood that this happened? And that is simply the balance of probability, and that's all an employer has to satisfy themselves during an investigation, is having looked at everything, what's the likelihood that this happened? That's the balance of probability, and that's the standard of proof that's applied to all your workplace investigations. So, labour law. The principal purpose of labour law is to regulate, to support and to restrain the power of management and the power of organised labour. Now that's a quote from a guy called Otto Kahn-Freund, and it's from his book Labour and Law. So we've looked at the source of law, we've looked at common law, primary law, secondary, European Constitution, international. So just again, by way of introducing you into what's going to come along the course, we're going to have a look at labour law, and we will touch on various pieces of labour law. But just in your own minds to differentiate and to understand what labour law is and what labour law consists of. So in this definition, labour law, the principal purpose of it is to regulate, to support and to restrain the power of management and the power of organised labour. So it's a means of regulating and supporting the relationship between employers and trade unions, in other words. So labour law covers three different areas. The first one is employment law, and this is what we're going to be focusing on over the next 8 weeks. And employment law defines the relationship between employers and employees and the rights and duties of each. Now, trade union law is second part that labour law covers. But trade union law defines the rights and duties of trade unions and their members. And industrial relations law then, which specifies a framework for the resolution of disputes. Now, trade union law we're not going to touch much on over the next 8 weeks. Employment law will be our primary focus, but we'll also introduce industrial relations law. Now, just for yourselves to consider before we meet. Employment law defines the relationship between employers and employees and the rights and duties of each. So I want you just to consider what that means, what's that saying, and how industrial relations law might be different from employment law. So employment law defines the relationship between employers and employees and the rights and duties of each, whereas industrial relations law specifies a framework for the resolution of disputes. So just again, consider, and I suppose just to keep in your own mind, which is going to be important over the coming weeks, the difference between the two. And again, there will be clues in these slides, but just that you are clear in your own mind the difference between employment law and industrial relations law. So employment law then regulates the relationship between employers and individual employees and the rights and duties of each. It includes the contract of employment and all of the relevant primary and secondary legislation, as well as common law duties implied into the contract of employment. The contract of employment is the cornerstone of labour law. It can be dealt with through the Workplace Relations Commission adjudication services and the Labour Court, and sometimes in the civil courts. The various statutes, which are the piece of legislation, for example the Unfair Dismissals Act, defines the jurisdiction, the entitlement, the remedy, the fora and the appellate procedure. Again, don't get too worried about this. We'll have a look at this over the coming weeks. But just, I suppose, very briefly, the Unfair Dismissals Act, in order for a case to be taken, the WRC or Labour Court have to satisfy themselves that they have jurisdiction in which to hear the case. For example, in an unfair dismissal case, the Labour Court would have to satisfy themselves that a dismissal has taken place first of all. Because if a dismissal hasn't taken place, then they have no jurisdiction to hear the case under the Unfair Dismissals Act. Now, entitlement, is the employee entitled to avail of that piece of legislation? For example, have they been in employment for a year or longer? For example, are they an employee, or were they receiving cash in hand where there was no legally enforceable contract of employment? So does the employee have an entitlement to avail of the Labour Court or the WRC under the Unfair Dismissals Act? Now, the remedy in all legislation, if it's found that the person has been unfairly dismissed, what remedy can the Labour Court or the WRC apply? Now, for those who have been unfairly dismissed, the most common remedy is compensation. And again, we'll have a look at that in a little bit more detail as we go along over the coming weeks. So don't get too worried about this. This will all make sense to you as we go along over the weeks. The fora is just a fancy name for where the employee can take their case to. In this case, Unfair Dismissals Act, the fora would be the Workplace Relations Commission or the Labour Court. And the appellate procedure, if the case has gone to the Workplace Relations Commission, all recommendations, decisions from the WRC, the appellate procedure, it says how long you have to appeal the decision and where you appeal it to. So if it's an unfair dismissal, if the WRC has issued a decision, then the employee or the employer has 42 days in which to appeal the decision to the Labour Court. So all decisions from the WRC can be appealed to the Labour Court, and that's all that means. So trade union law. Trade union law sets out the rights and duties of trade unions and their members. For example, the Trade Union Act of 1871 to 1990 states that trade union is not criminal, trade union not unlawful for civil purposes, and regulations for registry. So a huge concern for trade unions at the turn of the 19th century. It was always a difficult line to walk for trade unions and representing workers and employers' rights. And it was always a fear of trade unions that they would leave themselves open to the law, to criminal proceedings. The Trade Union Act of 1871 and the 1990 Industrial Relations Act clearly states that if a trade union is following the procedure set out in those legislations and their collective actions are in furtherance of a trade dispute, then they are protected from proceedings or protected from tort, from being sued by employers. Now again, we will look at that in a little bit more detail as we go along, but that's what trade union law, trade union acts are about and what they define. So the Industrial Relations Acts, which we will look at, the 1990-2015, it's an act to make further and better provision for promoting harmonious relations between workers and employers. And again, there's the 1937, the Constitution plays its role in what employees and workers are entitled to. So we look at industrial relations law. This deals with the collective issues. So do you remember we said labour law is broken into three factions? We've got the employment law, which looks at the individual's relationship with their employer. We've got trade union law, which sets out how trade unions conduct their business and the relationship they have with their members. And finally, we've got industrial relations law. So industrial relations law, and this is the important distinction, deals with collective issues rather than individual rights. So it specifies a framework for the resolution of disputes and the regulation of relationships between employers and workers. Can be vindicated mainly via the state's industrial relations machinery, but also through the courts. Again, the state's industrial relations machinery is just another name for fora. So if we have a collective dispute in the workplace, we don't go to the adjudication services in the WRC, we go to the conciliation services of the WRC. And eventually we can end up in the labour court with either an individual or a collective issue. And again, we will explain this in more detail as we go along over the weeks. So it dealt with mainly in primary legislation. So the relationship, the collective relationship between workers, unions and the employer is dealt mainly by the Industrial Relations Act 1990 to 2015. And I've just set out, I suppose, in chart form here, the difference between industrial relations and the law. The difference between collective disputes and your right as an individual under employment law. So under industrial relations, facts, so when there's a collective dispute, collective issue, facts are determined according to what is accepted or disputed by the parties. Under law, the individual relation of the exact objective facts as accepted by the court. Industrial muscle is relevant under collective disputes. Industrial action or the threat of it may resolve a dispute. Under the law, industrial muscle is irrelevant. The law is the only consideration. A collective issue under industrial relations, what is important is what will settle the dispute and prevent another. However, under the law is the only consideration, and whatever will uphold the legal rights of the parties is what will be implemented. So the difference between a collective dispute and an individual dispute, in a collective dispute, the conciliation conference, for example, and we'll discuss that more as the weeks go on. Some of you will be very, very familiar with this stuff, others of you might not be. But just to say that in a conciliation conference, where a union may, we'll say for example, we've been looking for pay increases of 3%, 4%, and the employer is only offering 1%. We have the opportunity to go to the WRC conciliation conference, where an industrial relations officer will try and mediate a settlement that both parties can live with. Now, from that, there will be a conciliation conference agreement, or maybe agreement can't be reached, at which stage it will go to the Labour Court. But either way, if agreement is reached, it would have to go back to the members for them to ballot to accept or reject. If they accept it, that's fine, then the pay increase will be implemented. If rejected, it goes to the Labour Court as well. So the Labour Court again will listen to both parties. It won't mediate as such, but it will listen to the arguments of both parties and the evidence, of course, presented. The unions will say, look at similar industries, this is the wage increases that have been given. They will look at inflation, etc. All of that evidence will be presented. The court then will issue a recommendation, and the recommendation will not be legally binding as such, in that under the Industrial Relations Act, the recommendation, because industrial relations law is voluntary, the employer can refuse to implement it if they don't agree with it. But the Labour Court recommendation still has to go back to the members in order for them to ballot to accept or reject. If they accept and the employer accepts, that's fine. Now, if the employees were to accept and the employer is not to implement the pay increases, then industrial muscle becomes relevant, i.e. we may ballot our members then for industrial action up to and including strike action. So the law will only consider the law where industrial relations will look at what might or will settle this dispute. So what is acceptable to the parties is what will settle it, but not what is necessarily right or wrong. Where in law, acceptability to the parties is not an issue. The important issue is whether something is lawful or not. Under industrial relations, consideration for ongoing relationship between the parties is important. So when the Labour Court make a recommendation, they are also conscious of the continuing ongoing future relationship of the employees and their employer. Where in a legal case, that's not taken into account. The only context is the law. Under IR, the methods are used within the context of collective agreements and custom and practice. Under law, the only context is the law, and etc., and etc., and etc. Again, we'll have a look at it in a little bit more detail, and any questions you have come off from this sort of chart, keep it in mind and raise it in the classroom, and we'll have further discussion on it. Now again, we're coming to the end of week's 1 slideshow. But just in summary, Irish law is derived from 6 sources. It includes common law, acts of the Oireachtas, and European law. Common law, again, just to remember, is judge-made law, and many common law rights and duties are significant for employment law. They impact on each employee's contract of employment. The majority of employment law deals with individual rights, and industrial relations law deals mainly with collective issues. Now again, these are some of the references. If any of you want to look further into some of the information that has been provided in the slide, you're very welcome to do so. Again, I will send you out a copy of this video along with the slides for week 1. If you can't make it on the night, at least you have some understanding of the slideshow. And if any questions, if you can't make it on week 1 and you have any further questions to ask, email me directly or give me a call and we can discuss further. And again, for any of you that are going to be attending class on the first night on week 1, if you have any issues, again, any questions that arise from this slideshow, please do not hesitate to write down, document, because what we're trying to encourage is discussion during the classroom. I just don't want to be presenting a slideshow, but at least we can encourage and hopefully, we'll feel comfortable discussing and asking questions, and hopefully we'll operate the weeks like that as we go along. So look, with that, again, we've only taken 35 minutes, and I don't intend for any of these slideshows to go on maybe longer than that, especially the video that you're going to be receiving in advance of the classroom. So look at that, we leave it. And again, I look forward to seeing you on week 1. So take care and we'll talk. Bye bye.